back to the podcast HOA Hell. I'm your host, Michael Kushner, and with me today is Senior Associate at MBK Chapman, Sam Kill.
Good morning, Mike. How are you?
I'm great, thank you. Sam, a couple of housekeeping issues. Number one, we're having a technological problem today that we're going to have solved pretty quick. We're having an issue with our microphones, and so you might see Sam a few times throughout the episode pressing a button on his. It is the only solution we could do to keep gain interference from kind of interfering with the show. So bear with us on that. Next week, it will be fixed, and then we'll have new microphones and a whole new system in place to take out these technological issues. Concern number two is we're in our studio. Our studio, is, you can see from the walls, is pretty well soundproofed, but there's some construction going on in the offices next door, and doesn't look like they're going to stop anytime soon, and we're here very early in the morning. And so if you hear something like that, please forgive us. That's out of our control. But aside from that, the issue we're covering today, Sam, is one of, I think, significant importance, especially to our differently abled listeners out there who have service animals or individuals who have pets that they rely on for emotional support. Okay? So today, we're going to be talking about service animals and emotional support animals within the context of the Davis-Sterling Act and your HOA and the things your HOA can and can't do. Sam, generally, before we get into the nitty-gritty, what are your thoughts on this topic as a whole?
Well, it's a critical topic. We see this come up quite a bit, actually. I wouldn't say on a daily basis, but certainly at least once a week. And those folks who rely on service animals specifically, it's an imperative part of their life. It's critical. We take it very seriously, and whenever we step in, usually our success rate is extremely high because it's that paramount to their functioning. And so yeah, I hope this is of use to our listeners and viewers. And
I want to interrupt real quick. I think part of what you meant to say, and I think you did a good job saying it, but I want to just clarify. When it's a service animal issue, our success rate is beyond, it's in the 90%. Because those are more cut and dried, as you'll see today. But the disputes that we see, okay, I think the real nasty disputes occur with emotional support animals, precisely because there's so much more room for abuse. And that's the issue today. If you have a service animal, if you have a recognized disability, PTSD, or you're blind or deaf or whatever, and you have an actual service animal, which is very different, by the way, under the law, which we'll talk about today, there's very precious little your HOA can do. And so disputes are much easier to resolve because it's spectacularly hard for them to actually screw around with your rights. But emotional support animals, it's a much different bag, okay? So let's jump right in and let's define our terms. So I think we should start with service animals. We're going to go through the whole defining what a service animal is, talk about what the HOA can and can't do vis-a-vis your service animal. And then when we're done with that, we'll move on to emotional support animals. And then we'll close with kind of a wrapping up with both. But we're going to handle these separately because they are very separate, although there are similarities. Okay? For example, we'll get to this, but one of the big similarities between a service animal and an emotional support animal is they're both deemed assistance animals. But you're going to find something very interesting when it comes to a service animal. And when I get to that, I'll make sure to remind you folks, it's not a judgment call. It is just how the law looks at service animals, okay? So let's start with, at its nitty-gritty, at its most basic, a service animal is an animal that's trained to perform a specific function or a specific role or task for a person who has a disability of some sort, okay? For example, the most common, when you say a service animal, people often think of a guide dog for somebody that's blind, okay? That specific task is for the dog to lead the person in public, stop at crosswalks, when there's traffic. It's basically to guide them around so that the human isn't bumping into things or isn't walking into a dangerous condition. That's the service. Some service animals are trained to smell out seizures right before they happen. And they signal the person to either pull over if they're driving, because that could be deadly, or to sit down if they're in public standing up, because falling can be deadly, can hit your head. And you can YouTube that. I've seen them on YouTube where the dog will signal, the person will then get to somewhere safe, sit down, and then the dog will lay on top on their lap and they go into a seizure and the dog is there, that is a service. That's the task that dog is trained for. That's what we mean by that, okay? So it's when it comes to a service animal that performs a specific task for that person or accomplishes specific work, okay, for that person, and they are deemed as service animals as a result, there's very little the HOA can do. So Sam, there are only 2 questions, right, that an HOA can ask if a person has designated their animal as a service animal.
Yeah, that's exactly right. And it's astounding how many times they run afoul of this. But those 2 questions, Mike, are, is it a service animal, number 1? And number 2, what service does it provide? And it's really that simple. That's all they can ask.
Elaborate for me. What do you mean by is this a service animal? And number 2, what service does it provide? Elaborate on that.
So is it a service animal part? The designation there is it, as you explained in the lead up, is it intended to assist you with those disabilities, right? Is it designated to do that, right? That's critical.
Let me interrupt. I don't think that they could say, is it designated to do something for any of your disabilities? I think they have to ask, is it a service animal? Does it perform a specific task for you? But they can't ask what the task is.
Well, that's right. Not a specificity part of it, but is it a disability-related service animal to assist you with your disability and disability needs, right? Not the specificity part of it, but is it oriented towards that?
Yeah.
So that's what establishes whether it's a service animal or not. And the second part is, what service does it provide? And then I guess on that facet, you really you can address that relatively broadly. It doesn't have to be, here's what they can't ask you, and this is important to point this out. They can't ask you specific medical diagnosis. I mean, that's arguably running afoul of HIPAA.
They can't ask you, what is your disability? Yeah. So let me be clear. We in the 2 questions, we narrowed it down, or I reworded it to make it simple for our listeners, okay? Is your animal a service animal? Now, that implies with it, they can ask it in different words. They can say, does this dog or whatever, but we're gonna call it a dog today. We're gonna use dog, but you can have other animals, like even miniature horses, but we're gonna call it a dog today, just for ease and simplicity, okay? Does your animal perform a specific task to help you with a disability? They can ask that, but they can't ask you what the disability is. So, and then question number 2 is, what task does this dog perform for you, okay? What task does this animal perform? This animal is trained to sniff out when I'm about to have a seizure, or this animal is trained to help guide me when I'm walking because I have limited vision, or PTSD. I'll give you an example. Some people have, some returning soldiers in particular have animals that are designed or they're trained to go into an area where there's a certain number of people, a certain density of people, and do a quick investigation and make sure it's safe. PTS, and that's when we'll talk later about being off leash, right? Some dogs will go and run through a scenario, a quick area where the person's about to go into to make sure it's safe and come back to signal that everything is safe. That is a service. So you say this dog inspects public areas before I go into them to make sure they're safe for me. Right. Okay? That would be the service. They can't ask, well, why does he do that for you? They can't have you elaborate. They can ask, what service? He sniffs out seizures. He helps guide me when I'm walking. He helps with my PTSD. That's it. That's it, right, Sam?
No, that's exactly it. And so just to kind of round out that list of what they cannot ask is, in addition to those items, they cannot ask you for the pet. In this case, we designated dogs. They cannot ask for them to wear specialized outfits.
We'll get to that. We're going to get to that. We're jumping ahead because I want to get to that in due course, because before we go on, I want to talk about the 2 laws or the types of laws that kind of control this area, okay? So when it comes to service animals, there's federal and state law that apply that establish the rules we just told you about, so that the HOA can't ask more than those 2 things. In other words, where do those 2 things come from? Federal and state law. First one that most people jump to, and it's wrong, is, well, under the ADA, under the American with Disabilities Act, this should be it should be protected. I have a disability. This dog is helping me, and therefore I get an accommodation. No. The American with Disabilities Act applies to public accommodations. And the vast majority of the time, HOAs don't offer public accommodation. It doesn't matter if guests or members of the public can come in to visit somebody. That's not a public accommodation. So in most cases, the ADA has no application to HOAs. There is an exception, Sam. What's the exception?
Yeah. That's exactly right. The exception is when these HOAs actually open up their facilities to the public. For instance, they use their clubhouses for wedding venues, or they open
Wedding venues to the public.
To the public.
Okay.
Or they open up, let's say, their pickleball courts or tennis courts or their gyms to daily passes for the public at large to participate. And in those cases, obviously, that would bring them within the purview of the ADA, and that has heightened requirements.
Okay, great. That's exactly right. So there are some HOAs in our area in South Orange County. Can think of one in particular. I'll give you one example. In Nellygale opens up its opens up its horse facilities and its swimming pool and tennis courts to members of the public for a fee, and that money goes to the HOA, and it's a means of generating revenue for the HOA. In such cases like that, if I'm right about that, if I'm wrong, then it's an example. If I'm right, then it's a true example. In such cases, ADA would apply here, okay? But in most HOAs, that isn't the case. It's not in mine. I know it's not in yours. And so ADA is inapplicable, and so anybody that spouts the ADA off is not speaking with any degree of knowledge at all, okay? So what's left? Well, let's talk federal for a second. The Fair Housing Act, FHA. Fair Housing Act does apply because it's a housing act, not a disability act, and so it applies and it covers this exact issue. And so does California's Fair Housing Law, FHA, okay? So under federal and state law, not the ADA, which is federal, but not that, under the FHA and under the FEHA, that's where we get the rules we were just talking about a few minutes ago. And now we can move on to, okay, so homeowners that have a service animal can be asked those two questions by their HOA, okay? And then, in the context of those two questions, here's what they can't ask for. Let's talk about some of the things they can't ask you to do. Sam, I'll leave that to you.
Okay, all right. So we did briefly touch on this earlier, but basically they can't ask you for the medical diagnosis and specificity. They can't ask you for a registration in the context of dogs that we discussed, specifically as service animals. They can't ask you for the dogs to wear specialized outfits.
Not even one of those vests?
No, not really. Mm-hmm. They cannot ask for that or require it. I mean, it's up to you. People do it, but it's really voluntary. Another thing they can't ask you for is a special pet deposit or payment in connection with your service animal.
Let me ask you this, Sam. Let me ask you this. What if this HOA has a pet deposit requirement for all members who have pets?
It doesn't matter, and here's why. Because dogs that are designated or deemed...
We're calling them dogs, but
right.
any service animal. Yeah.
Service animals. Service animals are not technically deemed pets.
What?
Because they are more tantamount or analogous to a assistive device.
Okay. So what he just said was extremely important. I'm going to say it again to reiterate what you just said. Mm-hmm. Under the law, and this is the part where I wanted to tell you this is not a judgment call by anybody. It's how the law views... These are obviously animals, right? How the law views these animals. And they are pets in our minds. They're members of our family, okay? The law, when it comes to a service animal, does not designate them as a pet. They are called an assistive device, like a wheelchair or a cane or glasses, object. They are an assistive device. They are not a pet. So any pet deposit that is otherwise valid, that your HOA might have, usually in multifamily housing, there might be, high-rise condominiums, for example, could have pet deposit rules, do not apply to a service animal because they are not pets. They are your pet. They are your family members. We know that, but not under the eyes of the law. They are wheelchairs, okay? They are canes. They're walkers. That's all they are. And you can't ask for a deposit for wheelchairs and walkers.
Yeah. No, that's exactly right. And this is where a lot of these HOAs and HOA boards run afoul of these issues because it's very confusing to them. Mm-hmm.
That is a huge one. And you can understand the reasons for these strict limitations. It's so easy for somebody to cross the line that they have to have these bright lines. If you didn't have these bright lines under the law, then, you give an inch, they take a mile, that's what would happen. There would always be a I would even call it a blurring over the line. I would be calling it a stampede over the line, okay? And the whole framework here is designed to protect the privacy and I guess the privacy is the most important, of the individual with a disability. And you don't want intrusive questions from individual members of the board about your medical history and your medical past. Now, I'll say one more thing, because I know he wants to say he's champion. He wants to say something. Here's the thing. Is it easy? And we'll talk about this shortly in a minute. I'll cover it shortly. But is it easy for somebody to lie? I mean, those two questions, it's so easy to say yes and yes. Yes, it is easy to lie. But the law recognizes that and says that's the cost of doing business to protect privacy. Sam.
All I was going to add, and you covered it quite well, and that's really what it comes down to. But you have HIPAA, you have this element of embarrassment that folks who are asked to share more, that reason for the confidentiality and they're protecting their privacy really stems from multiple underlying critical factors, right, to protect them, really, and not to exacerbate their conditions or subject them to embarrassment or essentially being ostracized in some fashion. So it really, there are numerous important considerations there for them to limit the extent of exposure and disclosure as well.
Right, and that's why these exist, okay? Now that we've kind of gone through what the HOA can and can't do, what they can do is simple. 2 questions. That's it. You're done. That's it. Very simple. What they can't do is all the things you talked about, medical records, make you wear a vest, pay a deposit, all that stuff, okay? Let's talk about, do you need permission? Do you need permission from your board to have a service animal? No, you don't. We're gonna talk later about emotional support animals, and there can be some sort of application process because it's an accommodation type issue. But service animals, no. You can come home with your service animal on any given day, and a board member or the board as a unit can designate a board member to ask the 2 questions, and that's it. And you give your answer, and whatever your answer is, that's your answer, okay? Now, does that mean the HOA can't install any controls whatsoever on a person with a service animal? No, it doesn't mean that. There are certain things that HOAs can do to preserve health and safety of their communities, even as they relate to service animals. So let's talk about a couple of those, okay? And even these are not always absolute. And I hinted at this before when we were talking about PTSD, so we're going to get to that right now, okay? For the most part, with limited exceptions, which I'll talk about in a moment, an HOA can require a leash or a harness or a tether, that your service animal is always on a leash, harness, or tether. Now, when the exception applies, which we'll get to in a second, they can, as a substitute, say, okay, well, then the animal must be under your control at all times. And that's a big deal because presumably when an animal is leashed or tethered, they're under your control. The assumption is that you don't have a 4-year-old, leading a Great Dane by a leash, because when the Great Dane wants to take off after a rabbit or another person or a cat, the 4-year-old's going for a ride, usually a very fast ride. So that wouldn't, just because the dog has a tether doesn't mean the dog is under anybody's control if it's a 4-year-old holding the leash. But an adult holding the leash, a little bit different. So they can require leash or tether unless one of the services the animal provides requires them to be off leash, in which case the rule is the dog must be under your effective and immediate control. And that can be done either electronically with electronic collars, or a dog that you've put a lot of money and training into, like mine. I have protection dogs, as you know. I have 2 Belgian Malinois that are highly trained. They've probably each had over 1,000 hours of training in their lifetimes. And they are highly trained with voice commands. And if it weren't for leash laws, I'd never have to have them on a leash. The control that I have over both those dogs is so impressively incredible that people are amazed when they see them in public, okay? And so that's what that means. But let's talk about that exception. There are dogs that are trained to scout area, 15, 20 feet ahead of the person that they're accompanying, and then come back and basically signal that there's no threat. And these are people suffering, for example, from shell shock or PTSD, okay? And those dogs don't have to be on a leash. By law, they cannot be cited for being not on a leash, okay? So that would be voice or signal control, either by an electronic collar or voice control. And the training has to match that. See, these service dogs, because they're trained to perform specific tasks, usually have tremendous amount of training. If a service dog is aggressive, barks, lunges, those are things the HOA can step in and say, okay, we can discipline you for that because you don't have your dog under control. Because an under control dog will not do any of those things under any circumstances unless they are taunted or poked, in which case a dog can protect itself and its owner. Service dogs can bite if they are protecting the owner from some sort of physical attack, or if they're protecting themselves. We had a case with a service dog in their own yard, and the neighbor would poke the stick through the fence because he was assuming this dog was barking. This dog was never outside. This dog doesn't bark. This dog was highly trained. It was another dog. It was another neighbor dog from somewhere down the hill, right? You know, I think the neighbor immediately down here or down the slope, but it carried up the canyon. And this neighbor would poke this dog, and his hand got too close to that fence once, and the dog nailed him. He tried to go after our client. He lost. I'm sorry, but we had video of that, okay? We had video of him prodding the dog with a stick. The dog is allowed to defend itself. And that guy got what he deserved. And that was what was determined factually in the case, okay? But they can't bark excessively. If you have them outside when you're not going anywhere and they're barking, that is a nuisance. That can be disciplined, right? Stuff like that, right, Sam?
Exactly. I mean, you mentioned it. The nuisance provision would be uniformly applied. So if it's excessive, I mean, dogs bark. We know that.
Yes.
But if the growling or the aggressiveness or other propensities that kind of are not justified or there's no reasonable basis for it, then yes.
Yeah. And one last one we didn't mention, it should go without saying, is waste. Okay? If the individual cannot, because of the nature of the disability, cannot pick up the waste, then the individual has to have a helper who can. There's no situation where a service animal is just allowed to go to the bathroom with, go number 2 without it being picked up, okay? It might not be in the moment, but it's got to happen. So the HOA can monitor that as well. Now, I want before we head off to emotional support animals, I do want to cover one last thing, okay? In California, it is a crime. It is a misdemeanor under Penal Code 365.7 to lie about whether your animal is a service animal, or to even wear a vest that says service animal when they aren't actually trained to perform a service. Okay? And because of that, I strongly urge people not to do that. Now, will you get away with it? Sure, you could get away with it most of the time. Okay? But it is a crime. And if you are taking a risk, not only is it unethical, and not only does it diminish or dilute the importance of service animals to people who suffer from real disabilities, that's a big deal too, ethically. But it's also you're lying and you're committing a crime. So I'm here to tell you folks, you're taking your. I mean, I don't think they'd put you in jail for it. I think you'd probably get fined, but technically they could. It's a misdemeanor. And you can get fined and or sentenced to up to a year in jail. So be cautious about that. If your animal is not a service animal, don't say that he is or she, okay? And I think that's it for service animals, okay? Now let's move on to emotional support, okay? A little bit more muddy in here. Sam, do you want to talk about emotional support animals, just like what is an emotional support animal, or do you want me to handle that?
I mean, I can start us off. So with emotional support animals, and you said it, it's a bit muddy, and this is where a lot of the HOAs really get confused, and HOA boards, because they kind of conflate the two, and they're very distinct things. With emotional support animals, it's less so a medical device or assistive device as it is in the case of service animals. It's more so in the case of emotional support animals that they abate and help mitigate certain symptoms that the owner experiences. Right. So they're really there to aid and abet them.
Yes, and it doesn't have to be a disability per se.
Correct.
And they are. Here's the biggest difference. Okay, they aren't trained to provide a specific service to a person. Yeah. Their existence, their presence is the service. Mm-hmm. The support that they offer is their existence. The the dog being there and laying on the lap and coming up close and cuddling with you, that's the service. That's the emotional support. Other than being a cute, cuddly dog that hopefully is some sort of training to be comforting, that there are no independent services for which that dog was trained to do. There's no tasks that you could say, okay, what task has this dog been trained to perform for you? That's not present with an emotional support animal. They're there to provide exactly what it says, emotional support. Okay, it's very broad. Okay, now they aren't limited, therefore, to a specific set of criteria as to what's defined as, for example, in the case of a service animal with certain disabilities. Now, they are regarded assistance animals. They're called assistance animals, but they are not considered assistance devices.
That's right.
Okay? They are pets. However, they're still exempt from pet requirements anyway, because they're assistive. They're still called assistance animals. And so even though they can be deemed a pet, they are still exempt from those pet deposits, okay, that we talked about before. But that being said, the HOA has a lot more that it can ask for and that it can require for you to have an emotional support animal. And by the way, when we talk about for you to have, we're assuming that you would need the HOA's permission for some reason if it wasn't an emotional support animal. Let me explain what I mean by that before we go further, okay? Some HOAs have limits on the number of pets you can have. The Davis-Sterling Act says, as a matter of law, that everybody is entitled to have a dog, cat, bird, or fish, okay, as a pet. Those are the animals that are listed in the statute. There aren't other animals listed in the statute. Miniature horses, not listed. Chickens, not listed. Snakes, not listed, okay? So, conceivably, an HOA could ban those other things, okay? But under California law, they can't ban somebody from having at least one bird, dog, cat, or fish, okay? Now, some HOAs have the limits on number. We can't ban you from having any. You can have at least one, but no more than one. They can do that, okay? Some HOAs have bans on size and weight. Dogs are permitted, but not dogs larger than 50 pounds or 45 pounds or whatever it is. And there are some limitations that could be placed on certain breeds, but there has to be, and I talked about this in a couple of shorts. I have 2 separate shorts on our podcast. You can go look for them on this very issue, one on service animals and one on emotional support animals. But the point here is, if you live in an HOA that has one or more of those controls, the number of pets, the weight, the breed, that's when this matters. Because if none of those exist in your HOA, nobody ever has to know whether your pet is an emotional support animal or just a pet. It's not relevant. It only becomes relevant when you need an accommodation. That is, I need you to waive that rule. So, for example, let's say your HOA has a size requirement. No animals larger than 45 pounds, and you have a German Shepherd that an emotional support, because remember, service animals are relevant, but you have an emotional support German Shepherd that's 75, 80 pounds or more. That weight limitation is exempt if your animal is deemed an emotional support animal and you can pass what we're going to talk about, you pass the test, then the HOA can't limit it, notwithstanding the fact that their size limitation is otherwise enforceable. Or if it's a breed that is banned, let's say your HOA bans pit bulls, okay? That's one of the breeds that courts have actually upheld banning. So let's say you have a pit bull, but it's an emotional support pit bull and you otherwise meet the requirements, that breed banning will not apply to you. That's when this stuff matters. When there are no controls on pets, it doesn't matter, okay? So that's where we want to enter into this debate from, okay? Now, one thing that your HOA, and I'll let you talk about this, there's one thing your HOA can require, and that is they can say, okay, you are asking for an accommodation. You want us to waive one or more of our rules because your pet would otherwise violate, or that animal, we're calling them dogs today, would otherwise violate that rule. You're asking for an accommodation based on emotional support needs. We want a letter, right?
Yep.
From who, Sam?
All right, so what you're describing, Mike, is exactly right. And that's basically part of when you have this special accommodation request or a request for accommodation, and they can engage in this interactive process, as they call it.
But
And
who's
as
the
part of
letter
that,
from?
The letter could be from a therapist. It could be from a physician. It doesn't have to be specifically from one or the other, but it can be from anyone who's treating you for perhaps symptoms or flare-ups related to your condition, and they say there's a reasonable nexus, essentially, and they don't have to elaborate. But so long as there's some kind of a nexus or connection between those conditions or the set of conditions or the flare-ups of those being triggered with this animal, right, this emotional support animal helping and abating those or anticipatorily mitigating the risk of those flare-ups.
Right, exactly. So here's the important thing. Let me distill that, okay? They can require a written letter from a medical professional. A medical professional can be a social worker with a master's degree. It could be, a lot of them have MSW, right? Master's in social work. It can be a PhD, like a psychologist. It can be an MD, like a doctor. It does not have to be a doctor specializing in medical health, like a psychiatrist. It can be your family physician. It can be your podiatrist. It could be as long as the person is a medical professional, that's sufficient. And the letter has to say, it doesn't have to you don't have to go into history and details about what the letter could say. And this is kind of just take this, and I'll put something in the description to give you some wording that you might have your therapist, if you want to get it from a doctor or a therapist that here's some of the wording you could use. It's going to be generally along the following lines. Mr. Smith, Elmo is Mr. Smith's emotional support animal. And I am working with Mr. Smith on abating symptoms from a medical condition that I'm treating him for, and this animal has proven effective at ameliorating or abating some of the symptoms that he suffers from. That's it. You don't have to say what the diagnosis is. You don't have to say exactly why this animal in particular is necessary. You just have to say, I'm treating this person, and some of those symptoms are abated, some of the symptoms are abated by this animal. That's it. That's it. But they can ask for that letter in writing. Okay? What they can't do is then say, well, this wasn't specific enough. What's the diagnosis? What are you suffering? What do you have? What's your emotional need here? Okay? They can't say, what's your medical history? How long have you needed this? It seems suddenly, it just came on suddenly. They can't do any of that. Okay? They don't get to say, well, we want our medical professional that we'll pay at our expense, HOA's expense. We want them to evaluate you. No, that's not how this works. Okay? And Sam, can they, in the case of an emotional support animal, can they ask for a deposit since it is a pet necessarily?
The short answer is no.
Good.
They cannot.
No, they can't. No, they can't. They can ask for verification of the whatever, and that's provided in that letter. That is the verification, right? But they don't get to dig, okay? As long as that letter provides kind of the couple things we talked about. It identifies the fact that there's a condition you're being treated for without saying what the condition is, and that animal, and I would name the animal, that animal abates one or more of those symptoms is all that's necessary, okay? And the words emotional support should be in the letter as well, okay? Now, HOAs love to overreach, right? Don't they, Sam? They when it comes to emotional support animals, which is even more abused than service animals, they love to start digging. So let's talk about, because they treat them as pets, for example, let's talk about restricted access. Okay, service animals get to go everywhere. A kitchen, a restaurant, wherever. Yeah. What have HOAs done in terms of access? Let's talk about swimming pools or gyms or things like that when it comes to emotional support.
And that's exactly where I was going to go with this. They have basically prohibited pet access or pets in the amenities such as, let's say, gyms, pools, even some of the pickleball, tennis courts, and certain other areas that are not specifically designated as like a green belt for dogs, let's say. And they cannot do that in the case of service animals. Absolutely not.
Not service animals also.
And emotional support animals as well.
Animals,
no, they're included as well. So in those cases, they are there, as we described very extensively, to be not pets, but assistive devices medically, right, in connection with the owner's needs.
Well, service animal is an assistive device.
Right.
They are there as an assistance animal when it comes to an emotional support animal. I think that's what you meant. You might have said that.
I'm emphasizing the service animals because, it's a more heightened
but
need.
Let's focus on emotional support, okay? Emotional support animals. They are not assistive devices, but they are assistive. They do provide. They are assisted animals or assistive animals. Okay, and just like a service dog or a service animal, they are allowed to go anywhere in the HOA that the human is. Okay, as long as they're under control or leashed. Oh, that's another thing. With an emotional support animal, you're not going to get away with off leash. The dog has to be tethered. Okay, tied up to something. Right. But they can go in the pool area. They can go to the pickleball courts. They can go to the gym, as long as they're not damaging anything. Yeah. For example, if the dog, if part of your gym has these mats, these foam mats, and your dog has sharp claws, right? If the dog damages that, you can be asked to pay for that. So they might say, look, the dog can come in there with you, but you need to keep him off the mats. That's reasonable. Okay, that wouldn't work with a service animal. No. Okay, it would not work. But you'd have to pay for the mats. If you damage them, you still got to pay for them.
And one addition to that, same thing, and we mentioned this before, the growling or possibly threatening other users in these amenities, like at the gym, for instance, that also would run afoul of the rules.
Or pooping where they're not supposed to and not picking it up. All that stuff. All those rules still apply. So everything that applied with the service animal will obviously apply with an emotional support animal, plus all the other stuff that the HOA can do. So what I hope you understand is that you enjoy a great deal of protection, whether you have a service animal or you have an emotional support animal. You enjoy a great deal of protection, and there are powerful limits on what your HOA can and can't do. The maximum protection and the least amount that the HOA can do obviously applies to service animals. And then, it does drop a few levels when you get to an emotional support animal. But when it comes to where that dog or whatever can go, it's unlimited, anywhere you can. So let's say your HOA is running afoul. They're creating problems. Whether it's a service animal or emotional support animal, doesn't matter. Let's say your HOA is violating your rights, okay? What should you do? I'm going to run through these really fast, and then we're done, okay? Number one, and this is critical, put it in writing. Send an email to any directors you want, any managers you want, or all of them, and put the details in there. I have a service animal. I have a emotional support animal, Elmo. And recently, I was told to leave the pool. On this date, I was told to leave the pool. I explained that this was a service animal / emotional support animal, and it didn't change anything, and they made me leave. Or I informed so-and-so that this was a service animal, and then they proceeded to demand proof or I couldn't stay. Stuff like that. Put it in writing so it's out there, okay? Even if you have to be the one that's narrating what happened to set the record, okay? 2, draw boundaries. If your service animal or your emotional support animal is status is being challenged, remind them what protections this animal has. For example, if it's a service animal and they were asking for documentation, you can remind them, excuse me, you're allowed to ask me 2 questions. Is this a service animal under the law? And what service does this animal provide for me? You aren't allowed to ask me anything else. You did. I rejected that and you kicked me out. Put that in writing, okay? That's where you're drawing your boundaries, okay? Reject unlawful demands. Don't leave the pool next time. Stay there. Say, I am not leaving. Let them call the police. Do not leave. If it's somebody's private home, got to get out. But if it's common area, you're not trespassing. You own it as much as anybody else, and you're not breaking the rules. If you have a service animal and they ask you to leave because there are no animals of any kind allowed, or you're in the clubhouse during an event and there's a commercial kitchen there and there's food, you can't have an animal in a commercial kitchen. That is a myth. You can have a service animal because they're not animals, okay? They can ban an emotional support animal in some places, in some contexts, when it comes to food prep, but very limited. But a service animal, absolutely not. Reject it. Say, I'm not leaving. Let them discipline you. That's when you come to us, okay? Document everything because we're going to want that. And we're going to champ at the bit for this one, okay? I would skip IDR in cases like this because you already tried to explain that was setting your boundaries and that didn't work. IDR is not going to help. And that's when you come and you seek legal help. when you are actively kicked out, or the stress is too much for you and you don't want to, you know you're allowed to stay, even though they're telling you to leave, but you don't have the desire to get into that, then go ahead and leave if that's going to be too uncomfortable. But then the next call you make should be to our office, MBK Chapman. We will set your HOA straight. Folks, the law protects your right to have service animals. It protects your right to have emotional support animals. Do not let your HOA run over your rights. Do not let them bully you into capitulating or leaving somewhere that you have every right to be, just like anybody else, because the law will side with you. If you have any questions or comments you'd like to make, we'd love to hear from you. If you like this episode, be sure to hit the like button. And if you haven't already done so, please subscribe to the channel HOA Hell. Until next time, have a wonderful day.